Hello everybody, and thank you to ERA for inviting me. I'm very excited to be here to talk about this very interesting topic about the intersection of the right to information in the EU with the right to privacy and the right to personal data protection in the EU, which are implemented in the GDPR. So I want to first point out two things that I heard a bit in the previous presentation that I found very interesting. About data protection being this sort of a super right, or becoming this sort of super right. I think this is an argument that has some justification, but also I think it's important to note that the EU is quite unique in that it has two provisions for privacy and data protection in its charter. We have Article 7, which protects privacy, and then we have Article 8 for personal data protection, and they're formally two different articles, and also they have a slightly different scope. And that's also why I think there is this discrepancy sometimes with the case law of the Strasbourg court. And then also the heading is a bit confrontational, but I think actually privacy, data protection, the right to information often work very well together. Because in the end you need a certain amount of privacy and data protection to form opinions, to part opinions, to speak freely in a way, and to contribute to information. And if you want to read how it works, if this is not given, you can read Orwell 1984, or you can go to The Circle of Dave Eggers. They really demonstrate how a lack of privacy, a lack of data protection leads to inhibiting freedom of expression. Okay, so what will I do today? I will first very briefly introduce some concept of EU data protection law as it is in the GDPR that I think are of relevance if we look at the right to information. And then I will look at two conflicts I see between data protection and information. First of all, the conflict with Article 11 of the Charter, so freedom of expression, freedom of information. And then secondly, the conflict with access to documents, which the previous speaker explained very well. And then finally, if I have time, I also want to explain that data protection law in itself has informational rights. It gives informational powers to individuals that can be very useful in our modern society. Okay, to my very brief introduction to data protection law. I think first it's important to know that data protection is not just something that we find in a general data protection regulation, but it's actually quite widespread now in the EU legislative framework. We have in primary law a mandate to the EU legislator to adopt data protection acts in Article 16, and as I already mentioned, there is Article 8, a fundamental right to personal data protection. And those two provisions led to a wide mix of secondary instruments. We have some that explicitly only deal with data protection, like the GDPR. Then there's an instrument for law enforcement and one for the EU institutions. But also a lot of other instruments have a data protection part. For example, Europol regulation has a large part on data protection in Europol. I think Frontex also has some provisions on data protection in its instrument. So it's really a fragmented field in a way. Then to the concepts itself, if we apply EU data protection law, there's basically three things that need to be given. First of all, there needs to be personal data. The definition of personal data you can find in the GDPR Article 4. It's very broad. It's any information with which an individual can somehow be identified. If you read case law, then you see the court interprets this very broadly, like an IP address, even if it's not a fixed one, is personal data because there is some way to link it back to you. Then the second element that needs to be present, this personal data needs to be processed. And once again, the court is very generous with what's processing. Like also passive activities, like just storing data on your computer would already fulfill processing for EU data protection law. And then the last one, EU data protection law applies if there is either automation or some sort of system. And again, we have a very wide approach to how this is used in practice. There was this famous case for data protection lawyers at the Court of Justice in Luxembourg on the Jehovah's Witnesses, and they had a paper list with houses that they cannot contact anymore because people refused to engage with them. And for the court, this was a system of data processing. This was enough for the data protection law to apply. So what can we take away from this? Data protection law easily applies, but that does not mean that it prohibits processing. It just means its provision have to be followed. And then now I will talk about like 3 substantive part that we can find in the GDPR that I think are especially problematic if we don't look at the right to information. The first key principle of EU data protection law is that if you process personal data, it has to be for a certain purpose. And you need to be specific about this purpose. It's a principle of a purpose specification. So this means you need to say to the individual, okay, I'm processing your data for advertising purposes, or I'm processing your data because I have this government task to fulfill. You have to state this, and usually this is done in privacy policies or data protection policies. And the second consequence of this is you are then limited to this purpose. If you told an individual, I'm processing for advertising, this does not necessarily mean that you can then go and disclose this information to anybody else. And this is where there could be a conflict with the right to information, because the purpose that was stated might not include disclosure. Especially if it's a government agency, they might run into problems here. Then this leads us to a similar principle of EU data protection law, that processing always needs to have an anchor point in data protection legislation. And the GDPR gives 6 such anchors in Article 6. The most famous one is, of course, consent, that with the consent of the individual you are allowed to process the data. But it's important to note that there are 5 other grounds, and actually in the data protection community there is now a lot of movement away from consent because it's potentially too easily given away. Like, people do not think maybe enough about what they're consenting to, or there's a certain consent fatigue that you just ask constantly to review some revisions. So this again can conflict with the right to information, because the anchor point you chose might not include that you can disclose this information to others. So you might have to either find a new one or try to find some sort of exception to this provision. And then finally, data protection law gives a set of rights to individuals about their own data, and one of them is that you have the right to erase data. And this is the right to be forgotten, always in exclamation marks. And this can be, of course, a problem for information, because if an individual considers that data about himself should be deleted because they say it's no longer relevant or it should not be out there, maybe this information has public interest. I mean, this has been used, for example, for people wanting to remove Google results about their criminal past, or also Google results because they were in the past active in a political organization. But you can say there is a certain interest in the public to see these things. So it's a very different balancing activity. So now to the first conflict I see with information rights in the EU and the GDPR. It's with freedom of information. Freedom of information is protected in Article 11 of the Charter, and I think it includes like 4 sets of informational rights. It has this right of the public to receive information. It's a right to share information. It's, of course, the freedom of the press and public watchdogs to report information. And since 2016, from the Strasbourg Court, there's also a limited right to access information, but only for press and public watchdogs. And we see that these different informational rights often interact with data protection or privacy, which I will show you now in a set of cases. The first case I want to talk about is this one. It's called Österreichischer Rundfunk. It's an old one from 2003, and in here there was a law in Austria where public employees, their salaries were published. So it was possible for everyone to know the salary of certain names. And in 2003, some employees and also some public institutions said, we are not sure that this is actually compatible with data protection law. So they brought a case to court. And the court here was very careful still. They said, yes, there is a right of the public to know about public expenditure and how the budget is being spent, but also this has to be balanced with the right of the individual and their right to privacy and personal data protection. So they said there needs to be a relationship of proportionality between publishing this information and the privacy of the person. And in this case, they did not make a decision. They said the national court has to see how the proportionality is in this case, but they gave very strong indications that they considered that potentially there might be other ways to give the public information about the budget that do not include the names of the persons. So this kind of thinking was then further developed in two more cases that I will only mention very briefly. The first one is Saturn Media, which is from Finland, I think. And as we already heard, in Finland they're very open about their information, and they publish, for example, tax information. And there was a company that, based on this publicly available information, built a SMS service. So if you sent a name there and a postcode, you got information about taxes of that person. And again, there was questions, I think, by the Finnish Data Protection Authority actually, is this compatible with EU data protection law? And once more, the court was still careful. Like they said, there is this right of the public to know, and it's important to be transparent about public budget and income, etc. But it needs to be balanced with the rights of the individual. But because this was under the Data Protection Directive already, the Data Protection Directive has in itself a sort of provision that allows balancing between freedom of expression and data protection in the context of journalism. And they considered that it could be possible that this company giving the service could be considered as a journalist, and therefore, if the Finnish authorities think this is the case, this would be appropriate balancing. So again, it really refers widely to the national courts to make a decision how they want to balance freedom of information, expression, and data protection. Then there was a case with a similar facts with the EU itself. Like the EU had a regulation that said we need to publish names and of the people who receive certain funds. And this also went to court, and once again the court goes, we need to carefully balance public information and privacy. And in this case, it actually found that the regulation of the EU went too far. It is not necessary to publish the names of individuals who receive funds. You can do this by just saying these are the funds, and then make some sort of general information or brackets. There's other ways to give this information. Then we move forward to the Google cases. These are like three cases about the right to be forgotten that I mentioned briefly in the beginning. And they actually raise very important issues about how the EU sees the relationship between the right to information and data protection. The first case here is about a Spanish man who, when he searched his own name in Google, found very old newspaper articles that his house has been taken by the state once as a compensation for debts he had. He thought this information was no longer relevant, it was very old, and actually the first thing he tried to do is delete it from the newspaper page. He went to the newspaper and said, can you please take this article down, it's no longer relevant. But the newspaper said, no, we don't edit news, we don't edit history, this has to stay. And the Data Protection Authority in Spain confirmed this. This is in public interest, that newspaper archives are not edited in that way. But he then said, okay, then can I at least remove it from the Google results? It does not have to be the first thing that shows up if somebody is looking for my name. And this case went to the Court of Justice. And here, I think the Court of Justice made this statement that leads to people saying that data protection became a sort of a super right, and it's probably correct if you look at this article, because the court says if there is a conflict between the right of the public to know and individuals' data protection rights, there is a presumption that the data protection rights override the right of the public to know, unless it's a question of public interest or it's a figure of public interest. And I think this is a very interesting statement the court made back then, and it had repeated it since then, because normally if you balance charter rights, the court never says one like generally outweighs the other. It's always very careful. But here it really says it overrides, as a general rule, the right of the internet users to know. So yeah, and of course this judgment led to many questions and confusion, and to more judgments. And the last two came in September this year. Again, it's with Google, and because I guess Google is the most prominent search engine in Europe. And it's about this, what can you erase from Google? The first case was because the French Data Protection Authority was questioning, okay, we have now, since the previous case, we have established that there is a right to remove certain search results from the list. But how far does this right go now? Because I think Google in the beginning, when they implemented this, they just put it to the like Google France or Google IT, and on the other ones you could still find it. So it was like if the French authority argued this right needs to be everywhere, like in the whole world you need to remove this information. But of course Google said this is a big problem if you look at freedom of information or freedom of expression, because other countries might have a different balancing outcome. So it went to the court, and the court did something very interesting. It said, yes, globally the balancing between information and data protection might be very different than in the EU. Therefore, the right to be forgotten in the EU from data protection law cannot go further than the scope of union law. But also the balancing might be different on a national level. So if a national authority thinks that to effectively protect data they need a worldwide right to be forgotten, then this is in their competence and it does not harm EU data protection law. So it's a very interesting judgment if you think that normally it's always about primacy, uniformity of union law, and here they kind of send the question back to national courts and say you can go further than us. And then the second judgment was about different situations where people wanted to remove data, but there was some public interest element. You can see the facts on the slide. The first one was some involvement in political activities. Then there was a representative of a religion. And then also people wanting to remove criminal allegations or court proceedings from the search results. Interestingly, before there was a case between the French authority and Google. Here they were on the same side because they both said you don't have a right to erase this information, but the individuals went to court. And here I think this judgment is a bit better than the other one. It's a bit more balanced. Here the court says, again, sadly, that in general the individual rights to data protection override freedom of information of the users, but again there is this if it's a public interest or a public figure, the balancing might be otherwise. And in this particular case, it says you have to balance Article 7, Article 8 and Article 11, and it found that the balance that here the French authority had already found by saying you cannot erase this information is within the lines of this balancing. So they said, yeah, this is information you cannot delete. From this we kind of then learned that at least this overriding can also be reversed. So there is situations where data protection does not trump freedom of information. Some conclusions from all this case law. I think in the beginning we saw that the court was very careful, very about proportionality, and left a lot up to the member states. Then we had this statement in Google Spain where they say in general individual data protection rights override the right of the public to know. But there's exceptions for public figure and the debate of public interest. And then we have this strange judgment that says that the balancing differs globally and it differs nationally, and therefore national law can find a completely different solution than on an EU level. And then, of course, the GDPR is not unaware of the conflicts between data protection and freedom of expression. So it has in itself a provision balancing those two, which is Article 85. What Article 85 does, it gives member state opportunity to adopt national rules, especially for journalism or some sort of expression, that can derogate from a lot of provisions of the data protection law. So far, we have 21 of those derogations notified to the Commission. So I think this shows that there's a lot of fragmentation and that each member state has a different outcome of this balancing of freedom of information and data protection. Then let's now go to the second conflict we have with data protection and then the public access to public documents regulation on an EU level. Here I think it's first interesting that data protection as a fundamental right in the Charter and access to documents in the Charter have a lot in common. They are kind of newer rights for the EU level. And there is a lot of overlap sometimes with older rights. For data protection, it's with privacy. For documents, it's with freedom of information. They both have like implementations in secondary law. And both are some sort concerned with transparency, because also in the end, what data protection wants to achieve is that when data is processed by companies or public authorities, that it's kind of transparent, that we know how these things are happening. So in a way, they share some concerns. But of course, they also do not always work together, which we can now see in a few cases. The first one is Bavarian Lager. This is an interesting case because there's two judgments. First, we have a court of first instance going one way, and then we have the grand chamber going the other way. This was a case where a company who was somehow initiated infringement proceedings at an EU level wanted to receive documents about a meeting where kind of important things have been decided. And this request was refused, at least full access was refused because the names of the people who participated in that meeting was not given. But the company really wanted those names because they saw that an association had participated in that meeting where there were some allegations of corruption. So they really wanted to know who exactly was in this meeting, so to understand how the outcome could happen. So they made an access request under the Public Access Regulation, and the Commission said no, because of data protection we cannot give you, can you give the names? And the first court here, the court of first instance here said this was not a matter of privacy and therefore the Commission should have given this access. So they said because these were professional people in their capacity of their association, so they are here in a professional capacity. So there was no interference with their private life if you release their names. And therefore the Commission should have granted this document. But then the Grand Chamber went in the other way. It says no, this would completely negate the data protection rules in the EU. You have to fully respect them as well. So they said you have to fully apply both the regulation for public access to documents and also the regulation about data protection in the EU. And how this balancing happens is actually very interesting, because as you might know, under the public access regulation, if you have a request, you do not have to give reasons. You can just put the request and that's it. But in data protection law, as I tried to point out in the beginning, due to this purpose specification, purpose limitation, and the legal basis, you have to be very, there have to be a lot of reasons. You have to argue why you need this data. And to find a balance between these two provisions, the court said, okay, if you request a document where there's some sort of personal data in it, you have to state some sort of reasons, or you have to give information so that the Commission can assess what's your purpose, what's your legal ground for processing this information. So in a way, it introduced that you have to state reasons if there is personal data in a document. Because in this particular case, the company never gave any reasons because they insisted they don't have to, the case stopped there. So we didn't know quite, okay, what reasons do we now have to give to manage this balancing? But then there was another case in 2015 with a journalist who gave reasons. He also requested access to a list of names. This time it was a list of MEPs. And he gave two reasons why he needed that list. First, he said, this is a pension scheme by the parliament, it's public money being spent. There's a right of the public to know about public expenditure. So similar to the arguments we heard before. And then the second reason was that he suspected that there was a conflict of interest between parliamentarians voting on their pension scheme and then receiving money from that pension scheme. And he wanted to investigate that. For the first reason, the court was dismissive. It said it doesn't see the connection between the public's right to know about public expenditure and the public needing exactly the names of the MEPs participating. So it dismissed this claim. He said you have to show that this data is exactly what you need to achieve your aim. And here he said you could achieve information for the public in other ways without the names, just about talking about the scheme and how much money. There's other ways. But for the second one, it said, yeah, of course, a conflict of interest. For this, you really need the names. You need to know who is voting and who receives. So here, they saw justification to release the names to the journalist. So in the end, he got his list of names. And what we see from these two cases is that if the public access regulation interacts with data protection rules of the EU institutions, as soon as there's personal data involved in a document, and as I noted, personal data is very broad, then there's this additional obligation for the applicant to introduce some sort of reasons why they need the data. And in the second case, we then learned that these reasons need to be actually quite concrete, because they need to be able to justify that the data is being processed. And then finally, if you compare then these two sets of case law, I think it's very interesting that on the one hand, if it's about freedom of information, freedom of expression more generally, the court has this preference for data protection. So it generally prevails over freedom of information or freedom of expression, and a lot of it is then up to national law to balance out the details. But if it's about public access to documents, and I have to say, yeah, public access to documents in the EU, so under the regulation, it seems a bit more equal, though of course the additional requirement to state reasons is something that's introduced. And then it was already mentioned that the GDPR includes Article 86, which says you have to find a balance between those two things. But what I read so far in Article 86, it's a lot of confusion what this article actually is meant to say, because it seems very declaratory in nature. While we have Article 85, which really gave some powers to the member states to find solutions for this conflict, this one we just say you have to find a solution, but you cannot really derogate from the rules of the GDPR. So I'm curious to see how this is going to work out. And then my final point, the data protection in itself, as I said, has a goal of transparency. So it gives a lot of information rights to individuals to know about what happened to their own data. This is both ex ante, so this is the information you see in privacy policies and data protection policies, where they have to give you some general indication what is going to happen to your data. I'm not saying this is very well done currently, but this is, I think, a good idea that hopefully will improve. And then the second right that's, I think, much more interesting is that as an individual, you have a right to access your own data. And this is a right, first of all, to receive a copy of your data that an institution or a company holds. And secondly, to receive concrete information, what is happening to your data in that company or that institution. And I think this will become and is becoming very important, because especially if you think about the use of algorithms, of automated systems in public administration. I know that in France they're now experimenting with algorithms determining to which university you can go. I think in Germany also there was some tests like this. And here I think maybe with the right of access or like in general information about how these decisions are made, you could gain important knowledge about how is a place allocated to you, what matters in these decisions. Because for me what I think is most scary is that we go into a system where computers make all the decisions without much transparency, and I think here is much overlap with the general goal of access to information. We go into a system where computers make all decisions and we don't understand them, and actually nobody understands them, because it's an algorithm drawing from all fields of information, putting it together. And I think here data protection plays a crucial role, because it has this demand that things need to be transparent, that individuals need to understand what is happening to their data. And I think this is going to be very crucial. And I saw some cases already where activists are using this right of access, but also a right to public information, to figure out how, for example, credit scoring algorithms are working, how they are assigning credit scores, what are they taking into account? Are they maybe taking into account things that are discriminatory or that you should not take into account? So I think this is an interesting field where data protection is giving information in itself, so not always opposing, but also for information. Okay, and then to my conclusions, I think it's important to see that data protection is a very broad field. There's a lot of fundamental rights involved that you have to balance constantly, and the GDPR tries to do this in itself. And we will have to see how this will work out now in practice. Then if you have a case for balancing, you cannot have a formula to always know how the case will end, but because the circumstances of each case are very important. But we see a bit of a worrying tendency of the Court of Justice to say data protection goes over information, which I think this is something we have to watch closely. And then finally, the GDPR itself offers a lot of interesting transparency opportunities that I think will become very important. And then also because the GDPR is cross-regulation, so it does not only apply to public authorities or only to private companies, but it applies to both. So it's a really broad field, and that's why also the rights it offers can be used in a lot of contexts. And I think transparency of governments is very important, but transparency of private companies can be equally important, especially if we have such huge companies as Google, Facebook, determining so much of our life. I think transparency here will become also a crucial theme. And I thank you for your attention, and I'm looking forward to questions.